Section 21 of Tribal Custom in Anglo-Saxon Law. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Ernst Schnell. Tribal Customs in Anglo-Saxon Law by Frederic Seebohm. Chapter 8. The Tribal Customs of the Oldest Scandinavian Laws. Section 3. Part 3. The gradations of social rank disclosed by the weregelds, etc. We are now able to devote attention to the interesting question of the gradations of social rank under Norse tribal custom, and we are fortunate to have the guidance of Dr. Konrad von Maure's valuable paper written in 1878 and entitled Die Freigelassenen nach altnorwegischem Rechte. Although tribal custom, viewed as we view it after the acceptance of Christianity, may not be altogether what it was originally in its actual working, yet still it is worth while to seek for the principles underlying the separating lines between social conditions as revealed in the laws. So far as they can be discovered, they are sure to be instructive, for they cannot have been the result of this sudden change in religion. Their roots, at any rate, go far back into tribal custom, however much, as in other cases, the Church may have adopted and modified what it could not eradicate. The hard lines of distinction between social classes were kept up even in the churchyard. Kirkegarde er skipt I fjördanger til grifter. Skal grafwa lendamen avstanna kirku och landsuder under uxadrapa efter egu lut I kirkegert. En efter egi lut I kirkegert, da skulle der ligga I bondalego. Da skal grafwa halsmen och dera börn. Ennes kirkegarde, da skal grafwa hjonmans, och da män räkna ero att sy får strandu, och hafwa harskurt I norrena. En if mader lägger man I frielskjafua lego, säkert 6 aurum. En if mader grafwa fjallskjafua I lösinga lego, säkert 12 aurum. Grafwa lösinga I halsmans lego, säkert 3 merkum. The churchyard is divided into 4 quarters for burial. Landmen shall be buried to the east and southeast of the church, under the eavesdrop, if they have taken part in the building of the church. If they have not done that, they shall lie in the burial place of a bonde. Next to them shall be buried houls and their children. And next to the churchyard wall shall be buried the servants, thralls of a man, and those who are cast upon the seashore and whose hair is cut in the Norwegian manner. If a man buries a thrall in the burying place of a fjallskjaf, he is liable to pay 6 aurar. If a man buries a fjallskjaf in the burial place of a leysing, he is liable to pay 12 aurar. If he buries a leysing in the burial place of a hauld, he is liable to pay 3 marks. Borgarthing Law 13. Referring to the gradations of ret, it will be seen that there are apparently 2 classes of leysings, whose social condition was next above the thrall at the bottom of the ladder. This was first made clear by Konrad von Maurer. The thrall, who by purchase or by gift had been made a freedman, frialskjafi, had only taken the first step towards even that limited amount of freedom which belonged to the leysing. Another step had to be made good before he became a full leysing, and the step was accomplished by the ceremony of making his freedom ale. The leysing before making his freedom ale was still so far the property of his master that his children did not inherit his goods. They belonged to his master. Nu ero bröder tver föder upp anotger at eins mans, och ero der bäde bröder och fostbröder, och leisax der undandratne sinum, och fyrask egi foster, egi sammanverk och orko. Da kommer fartvega, deira till annars arvs. Börn dera komma egi till, nema der geri frälsis ölsit. If 2 brothers are brought up as thralls at one man's house, and are both brothers and foster brothers, and they are freed by their master and continue in fosterage, and have their work and employment together, then either of them inherits from the other. Their children do not inherit from them unless they make their freedom ale. Gulathing 65. This passage shows that the link of blood relationship between two brothers and foster brothers, by reason of their being fostered together in the case of thralls, was recognized before that between parent and child. It was the fosterage in this case which had forged the link. Blood relationship in thraldom counted for nothing. The ceremony of making a freedom ale is thus described in the two laws. Nu vil leisingi rada kaupum sinum og kvanfengum, da skal han gera frelsesöl sitt, thrigja salda öl hit minsta, og bjóða skapdrottne hans til medvatom, og bjóða eigi sökunautum hans til, og sissa hanom i öndvege, og legja 6 aura i skalar hin fyrsta eftan, og bjóða hanom leisingsaura. Nu ef han teker vid, það vel, en ef han gefra upp, það sem goldet se. Ef threll kemur a gjörd edda vir, það skal han gera frelsesöl sitt, ver mader nju mele öl, og skera a vedr. Et borin mader skal höfut afskera, en skrapdrottning han skal taka haslausen av halse honom. Nu vil skrapdrottning hans leifa honom att gera frelsesöl sitt. Da skal han beida han med vata tve att han megi gera frelsesöl sitt, och bjóda honom med 5:e man till ölders dress han gerir frelsesöl sitt. Da skal han då gera och lita öndväg i hans och gono hans kurtligja. Gulathing Law 62. If a leasing wishes to have control of his bargains and his marriage, he shall make his freedom ale out of at least 3 siftfuls of malt, and invite his master to it, in the hearing of witnesses, and not invite his master's foes, and seat him in the high seat, and lay 6 aura in the scales the first evening of the banquet, and offer him the leasing's fee. If he takes it, that is well. If he remits the sum, it is as if it had been paid. Frostathing Law 9:12. If a thrall takes up land or sets up house, he shall make his freedom ale, every man of 9 mäler, equals 1.5 siftfuls of malt, and kill a wether. A free-born man shall cut off its head, and his master shall take the neck release off his neck. If his master will allow him to make his freedom ale, he shall ask his leave to make it, in the hearing of 2 witnesses, and invite him and 4 with him to his freedom ale. If they do not come, yet he shall make the ale, and let the high seat for his master and his master's wife stand empty. A master might dispense with this formality. He might take his thrall to church, or seat him on the kist, and if then he proceeded formally to free him from all debts and dues, the leasing need not make his freedom ale. G. 61. Now let us see what change in social position and rights the ceremony of making freedom ale, or its substitute, produced. The leasing was still unfree in the sense that he could not leave his master. The following is from the Gulathing Law 67. Nu förleisingi or fulki fyri utan rat drottinsins, och aflar ser där 4 edda kaupa, da skall skapdotten vara efter med vata. If han vill afterfara, da väl. En if han vill eigi afterfara, da lady han vittni a hon hanom att han leasing i hans, och föri han afterfart sem han vill lausan, edda bundin och setja han i sessim sama, där sem han var fyr. Now a leasing leaves the district without the advice or will of his master, and earns property or concludes bargains, then his master shall go after him with witnesses. If he is willing to come back, that is well. If he is not willing, he, the master, shall call witnesses that he is his leasing, and bring him back, fettered or unfettered, as he likes, and set him in the same seat that he had formerly. But on the other side, the master might not sell even a thrall out of the land. F 1120, so that probably he could not turn his leasing adrift at his pleasure. The leasing remained under thermsel towards his master, or obligations involving personal loyalty and duty, and upon any breach of these he could be put back into thraldom. En hef han gera einvern lutera, da skal han fara after I sessin sama han var fyr, og leisask thedan vadaurum. Fesinu hever han og fyrigord. Should he make himself guilty of any of these things, he shall go back to the seat in which he sat formerly, and buy himself free out of it with money to his value, and his property is forfeited. G 66. The reason assigned in the clause above quoted for the desire to make freedom ale was that the leasing might have control of his bargains and his marriage. He gained therefore both as regards property and also in family rights. In Gulathing Law 63 is described what happened on his marriage. If he marries a kin-born, Edborin woman, and they afterwards separate, all the children go with her. He, not being kin-born, has no kindred. She, being kin-born, her kindred have rights over her and obligations as to her children. En if hon verder fyrdaud, da skolo børn verve til fader sinds after, og etter fe hans medan dat til. En da dat alt ettet, da skolo børn after verva I hit betre kin, en han underskap drotten sin. If she die first, all the children shall go back to their father, and eat his property so long as it lasts. And after it is all eaten up, all the children shall go back to the better kin, and he back to his master. If one leasing marries another, and both father and mother have made their freedom ale, the children of the marriage inherit from both. This is the beginning of the rights to inherit. But it is accompanied by the obligation to keep the children, who are no longer thralls of the master, but leasings like their parents. What happens then if the parents fall into poverty and cannot keep their children? Is the master to keep them, or are they to starve? En if thou verda ad drotum, da dat gravgangsmen, skal grava grøf I kirkegarde, og setja thou dari, og lata der deia. Take skapdrotten dat lengst lever, og further dat sidan. 63. If they come to extreme want, they are gravgangsmen. A grave shall be dug in the churchyard, and they shall be put into it and left to die there. The master shall take out the one who lives the longest, and feed that one thereafter. But it is not all leasing families which come to this gruesome pass. It may be presumed that the leasing, who has made his freedom ale and married, and could make his own bargains, and keep what property he and his wife could accumulate, was mostly prosperous. In clause 106, the rules as to leasing inheritance are described. If the leasing, who made his freedom ale, afterwards had children, they could inherit. But he had no other kin who could inherit. So if he died childless, the master took the property. As generation after generation passed, and a wider kindred was formed, any one of his, the leasing's kin, took in preference to the master and his descendants. But the rights or chances of inheritance on the side of the master's family did not cease for 9 generations from the first leasing who had made his freedom ale. So that if a leasing even of the 8th generation died without kin, the inheritance in this extreme case went to the descendants of the master of the first leasing, to the 9th knee, rather than pass by failure of kin to the king. Leasings erf skala taka til 9. knes, fyren under konungange. Degar leasing som taker efter fader sin, da taker hver efter annan. Nu verder daar aldaude arfer I leasingskinni, og engisa mader, da I erfdatale vita han, andader årleisingskinni nu. Da skall hin och skaptortens kvisel taka till njondaknäs för en under kanongånge. Då att sa se hin att det andader fra läsingjanom. GC 106. A lezing's inheritance shall be taken to the 9th knee before it falls to the king. When a lezing's son takes after his father, then let one take after the other. If in a lezing's kin there comes to be an all-dead inheritance, and no one has inheritance right after the deceased man of the lezing's kin, then one of his master's kin shall take to the 9th knee before it falls to the king, even though the deceased man be the 8th from the lezing. Thus we seem to see the family of the lezing, who had made his freedom ale, gradually growing up into a kindred in successive stages, until in the 9th generation a kindred of lezings had been fully formed and might be very numerous. In the corresponding clause in the Frostating law, 9.11, further details are mentioned. If not previously purchased by agreement with the master, the thermsel came to an end after 4 generations. That is, the 5th generation was free from them. They lasted, therefore, over the first 4 generations from the original lezing to his great-grandchildren. For these 4 generations, the lezing and his descendants were the lezings of the master and his descendants. Then the clause goes on to show that the first lezing, having made his freedom ale, shall take inheritance only of his son and daughter, and of his own freedmen. The sons of this lezing take inheritance from 6 persons, viz. father, mother, sons, daughters, brothers, sisters, and 7thly, from any freedmen of their own. Sva skall soner lezinga taka och soner och dess soner, och sva dotter och syster, sem soner och bröder, efter ego till. Och sva skall far dera hygja för ödru. So shall the son of a lezing take, and his son's son, grandson, and his son, great-grandson, and daughter and sister like son and brother, if there are none of these. Each of these shall provide for the other. Failing these lezing claimants, the inheritance rights revert to the master to the 9th knee, and it is added, also providing for these if needed. There is here something very much like the Cymric gwely, or family of descendants of a great-grandfather, with rights of maintenance under the rules of tir gweliog, and mutual liability. Until a kindred has been formed, the master's obligation to provide for the lezing remains, and it does not cease altogether until the kindred is complete. In the meantime, as the kindred is formed, its members are mutually liable for each other's maintenance. In this respect, within the group of descendants of a great-grandfather, there is solidarity for maintenance as well as weargeld. We are dealing evidently here with a family of lezings growing into a kindred, as under Cymric custom the family of the Ailt and the Althoot grew into a kindred. During all these 4 generations the family were lezings with the ret of 6 öres. But the 5th generation seems to rise into a 2nd grade of social rank, and to attain the rank of lezing sons, with the ret of 8 öres. And further, in another 4 generations, those of the 9th generation again rise in social rank, and seem to become arborin or etborin men, i.e. men born in a kindred, with the ret of 16 öres. They can now boast of a full lezing kindred. Their father, grandfather, and great-grandfather were born in a kindred, and they have now full rights of inheritance. The master and his descendants have no further hold on them or obligation for their maintenance. Any lapsed inheritance now goes direct to the king. The arborin or etborin man, therefore, seems at last, at the moment when a full kindred of his own has risen up to swear for him and protect him by feud or weargeld, to have become clear from any claims on the master's side. And accordingly, if any claim be set up, he has to prove his freedom by witnesses that he can count 4 of his forefathers as arborin men, and himself the 5th. That is, he shows that his great-grandfather was a man with an et or kindred. If he can prove this, he is free from any claim in regard to his lezing descent. En ef saga kallas arborin, För sökväder, där tälle han 4 langfäder sina till arborina manna, en skjälfra han hin 5 och hafi till dess tvärboende vittni arborina. En if han svalid laus, att han fär det ägi, och hefur då dessa vörn fyrer ser, da sanni et sina arbona med gudsskrilum. En if han värde skryr med järne äda vittnesbörd, da gjaldi hin honom fullrätti, en biskop i eida sekt. En if han fär sig ägi skirt, da hefur han fyrigård för sino ölu vid skrapdortnin, och ligga att 3 märker sylfyrmättnar nämmer han launi av ser, och sva vanar man. Frostathing 9:10. But if the accused calls himself Arborin, let him reckon up 4 of his forefathers as Arborin men, he being the 5th himself, and have for it the evidence of 2 Arborin householders. But if he is so supportless that he does not get this, and yet sets up this defense, viz. That he is Arborin, then he shall prove his kin to be Arborin by ordeal, and if he is cleared by iron or evidence, the other shall pay him full atonement, and to the bishop an oath fine. If he cannot clear himself, he has forfeited all his property to his master, and is liable to pay 3 marks in silver, unless he work it off. The same applies to a vanarman, man of hope, i.e., the higher class of lazing. So far the conclusions drawn from the laws respecting the lazing do not vary much from the views expounded by Dr. Konrad von Maurer in his Die Freigelassenen nach altnorwegischem Rechte, and confirmed by so great an authority they can hardly have wandered very far from the truth. The theory of this gradual growth of the kindred of the lazing is so nearly analogous to that of the Cymric Altud and the Irish Gwydir, and at the same time so logical when the tribal theory of blood relationship is applied to it, that we cannot be dealing with a fanciful theory of legal enthusiasts which have never had an actual place in practical life. Behind all this imperfect description in the laws of social conditions and landholding there was, no doubt, a reality the features of which may be difficult to grasp from our modern point of view, but which become, I think, fairly intelligible when approached from a tribal point of view. When we consider that in the course of the successive generations during which some kind of shadowy lordship seems to have prevailed over the family of lazings, they must generally have multiplied into considerable numbers, and that the descendants of the master of the lazing, who made freedom ale, must during the same period also have multiplied. And further, when we consider that the descendants of the lazing were in some sense, it would seem, adscripti glebe, we have to recognize not merely a relation between individuals, but something approaching to a relation between 2 classes, tribesmen and non-tribesmen, the one in some sense in a kind of servitude to the other. In other words, we have to conceive of a kindred of half-free tenants living under the joint shadowy lordship of a kindred of fully free men, probably in some tribal sense landowners, with complicated tribal rights among themselves. It would seem that this semi-subject class of lazings were mostly the descendants of a class of thralls. It may be perhaps in origin some conquered race, members of which had gradually grown into lazings, and were now gradually in successive stages growing into freemen. Before we can fully understand this process, we must examine the other side of the question and learn what was the position of the fully free class, by whom this more or less shadowy lordship over the lazings class was exercised. In the meantime, it may be remarked that the shadowy lordship of one class or tribe over another finds parallels enough in Indian experience, and that, coming nearer home, we have only to remember the petty exactions of the cadets of French noble families upon the peasantry over whom their family or the feudal head of it held a quasi-manorial lordship. 4. The classes of freemen and their relation to land. Following again the clue of the statements of the personal right of the different classes, and commencing with the bonde or ordinary freeman settled upon land, and presumably having in some sense, as in Wales, originally tribal rights to share in the land or its use, The next class, which claims attention above the bonde, is the odalman, or odal-born man, or hald, whose weregeld of 96 or 100 cows was taken as that of the full and typical freeman. Now in the Frostathing law there is a statement as follows. Engumani verder gjörd att odali 4 en 3 langfäder ha förat och kommer under hin 4 samflit. 12:4. No man's land becomes an odal to him until 3 forefathers have owned it, and it falls to the 4th in unbroken succession. And again in the Guldathing law is the following. Nu skall der jarda telja odrolom skolo fylgja. Så ein ave ever ave levt. 270. Now shall the lands be told that are odal. The first is the one which grandfather has left to grandfather. His grandfather's grandfather had the land. The odal-born man inherits land from his grandfather's grandfather. The son of an odal man, who claims odal as odal by inheritance, counts 4 or 5 forefathers who had the land before him. In Gulathing law, chapter 266, is a description of the mode of settling a claim as to land. It describes the sitting of the open-air court, from which both bogilsmen and nefgilsmen and relations by marriage of the claimant are excluded as ineligible. The calling of witnesses all to be odal-born men of the same fylke as that in which the land lies, and so on. The validity of the claim is made to rest according to this statement upon the ability to count up 5 forefathers who have possessed that land, while the 6th possessed it both by ownership and by odal. Der skall tälja till langfädrar sina oerat ava en sahin seti erbede att de eigen och att aderle. 266. They, the men who claim odal, shall count 5 of their forefathers who have owned the land, and the 6th having it both in ownership and odal. If then, at the time of the laws, we look at the class of landowners who were prominent as odalmen or halds, typical men with weregelds originally of 100 cows, they were not only men of full kindred, whose full pedigree of freedom went back the necessary 9 generations, but their grandfather's grandfather must have possessed the land. The 6th generation of owners were the first to hold land both in ownership and odal. The steps in the rank of Norse aristocracy were marked, therefore, as in the case of the more dependent class, by the number of the generations of ancestors through whom they could claim their landed rights. Nor in the case of the odal-born man, any more than in the case of the lazing, must we look upon the odal man or hald merely as a detached individual landowner owning his own separate estate, like a modern country squire. Such a conception would be far indeed from the truth. It must be remembered that holdings in odal were subject to rules of division. Moreover, indications appear in the laws that the division was not merely one between the heirs of a single holder, but something more like what took place between the group of kinsmen in the case of the Cymric Gweli and Tir Gweliog. How otherwise can this clause be read? Odals jarder. Nu skall der jarde telja odrlom skolo fylgja. Så ein ave hever ave levt. Så önnur golden in mansgjöld. Der skolo odrlom fylgja, och allar där I odalskipti hava kommit med bredrom och med frändomsheim. Sick. Allar adrar aurum. G 270. Of odal lands. Now the lands shall be told which are odal. One is that left by grandfather to grandfather. Another is that paid as weregeld. These shall be odal, and all those which have come under odal division between brothers and their kinsmen. All other lands shall be counted aurar, money. At the time of the laws, owners of odal had, it appears, certain powers of selling their odal, but even then it was not an uncontrolled right of a man to do what he would with his own. His first act must be to go to the thing in autumn and offer it to his odal sharers, odalsnoter, one who has odal right to land in common with others. G 276. If a man buys without its having been thus offered, then the odal sharers may break that bargain. G. 277. Even when the sale and purchase have been made by the public ceremony of skating, i.e. by taking earth from the four corners of the hearth and from under the high seat, and where field and meadow meet, and with witnesses at the thing, G. 292, the odal sharers of the seller have the right to redeem it within a 12-month, G. 278. Take again the case of two brothers dividing odal, and observe how careful law and custom had been to prevent either of the odal sharers going out of the family. The odal rights between them were maintained for as many generations as must pass before the sharers could be united again by a lawful marriage between a son of one family and a daughter of the other. G. 282. One is tempted to say that here again there may be something very much like the Cymric gwely, and to suppose that marriage was forbidden within the gwely, for example between second cousins, and that the odal sharing continued so long as the gwely held together. Nu skipte bröder tver oderlom sina milli. Da skall tingat verva I da kvíselodal sem låten ero, bäði att bådom och att abus bjöda, tvi att eins, I adra kvísel eda söker prot eda a lauda aufreverde. En egi skiljask odal med dem att helder för en fartvägja, ma ega dotter annars. If two brothers divide their odals between them, the odals shall pass into the hands of the branch which receives them by lot, in respect both of right of redemption and of occupation. They shall only be offered to the other branch, if this one comes to utter poverty, or the inheritance is left without a legal heir. Yet the latter does not lose its right to the odals until each of the two can marry the other's daughter. If the family of one of the brothers sinks into utter poverty, or is left without a legal heir, the other family have the right of redemption and occupancy, and yet the poverty-stricken or heirless branch does not lose its right to the odal altogether. There is still the chance that its rights may be restored when a son on each side can marry a daughter of the other side. There is a further clause in the Gulathing law which provides that when land falls to a woman, the men of the kindred, if their relationship be so close as to be nefgildi or baugildi, that is, as we have seen, paternal and maternal relations, descendants of great-grandparents, have a right to redeem it from their kinswoman at 1/5 less than its value, paying 1/2 in gold and silver and the rest in thralls and cattle. The men then keep the odal, and their kinswoman keeps the orar. Even if odal has passed 3 times under the spindle, it comes back at last to the male kinsman. 275. Nu verður kona bágriger, verður hon bäde arva odals och aura, och a engi mader undan henne att leisa. Nu der konor, odals konor ero, och odrum skolo fylgja, dotter och syster och fadersyster och broderdotter och sonardotter. Der bágriger tver, dotter och syster. Der skolo baugum böta och sva taka sem karlmen, och sva egu der bod a jördum samt sem karlar. Nu der arva fader sins. Nu öner dotter ena, en öner sun ein. Da skall suner leisa undan frändkonom sinum sem lök till. En if en skiptits och onson in der döter, pascolo der leisa undan daim slikum aurum sem han leisti undan möder ptera, och skall da ligga jörtkir där sem komin Da jörd kommen trisvar under snud och under sneldo. If a woman is a baugrir, an only daughter who in default of heirs male could receive and pay weargeld, she inherits both odal and aurar, and no man requires to redeem it from her. The women who are odal women and take odal are daughter and sister, the father's sister, and brother's daughter, and son's daughter. Daughter and sister are two baugriar. They shall pay and take baugar as males, and they may redeem land as men. Now if they are their father's heirs, and one of them gives birth to a daughter, and the other to a son, the son shall redeem the odal from his kinswomen as the law is. But if things turn around again, and she has a son, and they, masculine, have daughters, they, masculine, shall redeem it from them, i.e. from the daughters, for the same payment by which he redeemed it from their mother, and the land shall then remain where it is. Then the land has passed 3 times under the spindle. Now when these remarkable survivals of tribal custom are found still remaining in the laws as to odal and odal sharers, and the rights of kinsmen who would have to pay wergel to redeem odal, so that it may be kept within the ring of odal sharers, they cannot be regarded as laws framed to meet the needs of individual land ownership. They come down in the laws as survivals of family ownership under tribal custom, and the principles of which are by no means wholly obsolete, even though society may have passed onwards some stages towards individual land ownership of the more modern type. And when we consider the solidarity of kindreds, as regards the payment of wergelds on the one hand, and the corresponding solidarity in the matter of land ownership on the other hand, we can hardly fail to recognize that the two are connected, that both spring from a tribal principle which lies at the root of tribal polity. The solidarity of kindreds, taken together with the liability of individuals to take their share in the payments for which their kindred is responsible, corresponds to the solidarity of odal landholding, taken together with the individual rights of the odal sharers. Unless every one in a kindred has his recognized tribal rights on the land, unless he were possessed of cattle and rights of grazing for their maintenance, how could he pay his quota of cattle to the Houls-wergeld of 100 cows? The two things seem to hang together, as in the Cambric instance, and the one makes the other possible. End of section 21.